Okay, I think we'll kick things off here. So today, Donata Skillrud, pardon me. She's the president over at a great company called Termigen, and they help businesses and organizations build bulletproof privacy policies. We're very happy to have her with us today and share her knowledge and expertise, given that this is such in the forefront right now. So if you guys have any questions, thoughts, stick those over in the Q&A at any time throughout the presentation, and then after we'll circle back up and open up the forum and talk to Donata in more depth about those questions. So Donata, take it away.
Awesome. Thank you, Josh. And thank you to everybody who's joining us. I'm very happy to be here. I did want to give a little bit of a disclaimer. I have my dog with me, so if you hear growling, that's the dog and not my stomach. So, all right, I'm going to share my screen here. And we are going to talk about the 3 things that agencies need to know about their clients' online privacy. And another disclaimer is anything that is presented today is for informational purposes only and should not be considered as legal advice. If you are looking for legal advice, I would definitely recommend speaking to an attorney in your area. So the things that we're going to talk about today is which websites need to have a privacy policy, why privacy policies are important, and why you should be the one to talk to your clients about privacy. I know that privacy can be a very intimidating and confusing topic because there's so many different resources out there, a lot of which are conflicting about what the actual requirements are and what all of these things mean. But I'm really hoping to kind of give you a good baseline overview of privacy policies and what they are and why your clients might need them. So a little bit about me. Sorry, I'm not sure why the images aren't working, but I'm a privacy and technology attorney and a certified information privacy professional. Like Josh said, I'm the president of Termigen, and I'm the legal engineer behind the policy questionnaires and text. And I'm responsible for keeping the policies up to date with changing privacy laws. So a huge part of my day consists of monitoring privacy laws and privacy bills. I also serve as the chair of the American Bar Association's e-Privacy Committee and the chair of the Chicago chapter of the International Association of Privacy Professionals. And lastly, I'm also the vice chair of the Chicago Bar Association's Privacy and Cybersecurity Committee. So some of you that might have been in the web design and development world for a few years might be a little bit confused as to why we're talking about this. So if you think about 5 or 10 years ago, privacy really wasn't such a big deal. Consumers didn't really care much about privacy, and companies didn't really care much about it either, unless you were in finance or you were in healthcare, or unless you were an attorney. It really didn't matter much. You would take some kind of template that you found online for your privacy policy, slap it on a website, and then never look at it again. And either fortunately or unfortunately, those times have changed. And that's really thanks to Facebook and the Cambridge Analytica scandal. So if you guys remember what that was, a few years ago, it came out that the firm Cambridge Analytica scraped the profiles and personal information of millions of Facebook users and then used that information to target political ads. So this was in the news a lot. And basically what it did, it exposed the dangers of sharing personal information with companies. And consumers saw the consequences of giving companies their personal information. So because of that, consumers started to get more and more concerned about what companies do with their personal information. So there's some great studies out there, but 2 of them that I'd like to highlight, at least right now. So a study by empathy.co found that 40% of consumers are concerned about what happens to their data when shopping online. And then a study by Consumer Reports found that 67% of Americans say there should be tougher penalties for companies that don't protect the privacy of consumers. And we also saw other countries such as the European Union passing privacy laws and providing consumer privacy rights. And that basically exposed the value of having privacy rights to consumers, especially to those in the United States, seeing that other countries provide consumer rights to their citizens and the United States really doesn't. And lastly, there is no federal privacy law in the United States that governs business websites. We do have a federal privacy law for healthcare and finance and things like that, but not for regular business websites collecting PII. And this caused consumers to push their state legislators to propose and pass privacy laws. So we've seen an increase in the proposal and passage of privacy laws, which require websites to take certain measures, such as have a privacy policy and provide certain privacy rights to consumers. All right, so now that we have this kind of background out of the way, let's talk about what websites need to have a privacy policy. And there's a lot of misconceptions here. So a lot of people think that only websites that share personal information need to have one, or only websites that sell it need to have one, or only e-commerce websites need to have one. And that's really not true. So in this first part, we'll talk about which websites need to have a privacy policy. So before we start on that, I did want to talk about one definition here, and I promise there's only one in this whole presentation, and that's personally identifiable information, otherwise called PII. And PII is any data that could identify somebody. So examples of PII would be names, emails, phone numbers, physical addresses. Also, IP addresses are a great example of PII as well. And really, any website that has a contact form collects PII. So if you think about the websites that you build for your clients, you could have a contact form, you can have an email newsletter sign up form, account creation forms, billing forms, or even analytics services like Google Analytics. All of those things collect PII. So they would collect names, emails, all of that kind of stuff. So I'm not sure why this image isn't working either, but it's an image of a contact form, and the contact form will collect names and emails, and somebody can contact you there and submit their information, whether they're interested in your products or services, things like that. And basically that form would collect names and emails, which are examples of PII. And really, any website that collects PII needs to have a privacy policy. Right? So any website that has any of those forms that collects names, emails, phone numbers, and IP addresses needs to have a privacy policy. All right, and then we're on to part 2. Why does PII collection and privacy matter? So again, I'm one of those people that if you tell me to do something, I'm much more likely to do it if I actually understand why. So I think that this part is really important. So there are a number of privacy laws that regulate the collection and use of PII. And basically, privacy laws can start applying to a website as soon as PII is actually collected. So you don't even need to use that PII, you don't need to share that PII, you don't need to sell it. All that you need to do is to collect the PII for the privacy laws to start applying to you. And privacy laws have a lot of different requirements, but essentially they require websites to have a privacy policy that makes certain disclosures. So if you look at a privacy policy in a very general sense, the meat and potatoes of a privacy policy consist of 3 disclosures. So what PII is collected, what is done with that PII, and who the PII is shared with. And all of those disclosures go into the privacy policy, and that's how a privacy policy is made. Now, to be clear, there are a lot more disclosures that are required in a privacy policy. These are just kind of the main ones that comprise the bulk of the privacy policy itself. And the way a privacy policy is made, or should be made, is you first have to figure out what privacy laws apply to that particular website and that business. And then you look through each privacy law to see what the disclosures are that are actually required. So there are, like I said, there's a number of privacy laws that apply to the collection of PII by websites. So you have privacy laws in the European Union, in the United Kingdom, California, Nevada, Delaware, Canada, and Australia. And there's also 2 new privacy laws that have been passed in the last 6 months, the Virginia Consumer Data Privacy Act and the Colorado Privacy Act, and both of those go into effect in 2023. What's really important about these laws is that they protect consumers and not businesses, which means that they have a really broad reach, meaning that they can apply to businesses outside of that state or country in which they were passed. So a great example is CalOPA, the California Online Privacy and Protection Act, which applies to any business website that collects the PII of California residents. Now, as you know, anybody from anywhere could potentially submit their PII to a website if it has a contact form. So that law will apply to virtually any business website out there. Same thing or very similar to Nevada Revised Statutes Chapter 603A. That one applies to anyone that does business with Nevada consumers. So if you have a customer that's located in Nevada, that law would apply to you, and you would be required to have a privacy policy that complies with that particular law. So when it comes to figuring out what privacy laws apply to your business, it's not really about where you're located. The things that you need to keep an eye out for is who you do business with, where your customers are located, where you offer goods and services, whose PII you're collecting online, and then also who you're tracking online. So a great example is the General Data Protection Regulation. That one applies to any business that is actually located in the European Union, or any business, regardless of their location, if you're offering goods or services to EU residents, or if you're tracking EU residents online through services such as analytics, right? So that's how you determine what privacy laws apply to you. And then you also need to keep an eye out for new privacy laws that pass. So like Virginia and Colorado, those require privacy policies to have certain disclosures before they go into effect in 2023. And then lastly, I wanted to mention that existing privacy laws are also getting amended on a frequent basis. So as more privacy affecting technologies are invented, as privacy practices change in companies, as the sale of PII becomes more prevalent with companies, legislatures are actually amending their privacy laws. So the CCPA, California Consumer Privacy Act, its amendment will go into effect in 2023 as well. Nevada's privacy law was recently updated. And then Canada's PIPEDA is actually considered to be updated as well soon. And if it does get updated, that will actually provide Canadians the right to sue businesses directly for privacy law violations. And what happens if you're not complying with a privacy law? So penalties for not complying with privacy laws range from $2,500 per violation to 20 million euros or more in total. And in this case, per violation does not mean per website or per policy. In this case, it actually means per website visitor whose privacy rights you infringed upon. So for example, if you have 100 website visitors from California for this particular month, and you don't have a compliant privacy policy, even though you're collecting the PII of California residents, that fine would be calculated as 2,500 times 100. So the fines can add up really quickly because they're calculated per violation, at least in the US. So it's definitely something to keep an eye out for and make sure that you have a privacy policy that complies with the privacy laws that apply to you. All right, so unfortunately, this image is not showing up. So I am going to have to pull it up here for you because it's a very important image. So please bear with me here. I'm going to pull up our privacy bill tracker. And basically, that privacy bill tracker tracks all of the proposed privacy bills in the United States right now. So this is the current version of the privacy bill tracker. You can find this on our blog. And essentially what this is it tracks all of the privacy bills that have been proposed in the United States right now. So we won't go through all of these bills because it would just take forever and we don't have that kind of time right now. But I did want to make a couple notes here. So all of these bills would require websites to have a privacy policy that makes specific disclosures. So if any of these pass, you might have to update your privacy policy because these bills can apply outside of the states in which they're passed. So if you're not located in any of these states, this is not something that you can just ignore. They can apply to you. If passed, they can apply to you even if you're not located in those states. Some of these bills include a business size limit, meaning that you have to make a certain amount of revenue or process the PII of a certain number of people for the bill to apply to you. But a lot of them don't. So a lot of them don't care about the size of your business. Some of these bills would allow consumers to sue businesses directly for violations. So that means that there would be an influx of lawsuits like we saw with the Americans with Disabilities Act and websites. Once consumers can sue, there are a lot more lawsuits that happen. And then also they would provide certain privacy rights to individuals, such as the right to access, delete, correct, opt out or require somebody to actually opt in to the collection and processing of their PII as well. So it's very important to note that you need to keep track of all of this, or if you don't have the time to keep track of all of this, have a resource that does keep track of all of this for you, because this is something that is constantly changing. And these bills aren't just being proposed and then kind of let out into the ether. They're actually being passed. So like I said earlier, Colorado and Virginia just passed their own privacy laws. And as you can see, more and more states are trying to get there as well. All right, so even if you're not that worried about the fines, there are other reasons for caring about privacy. So first, consumer interest. 84% of consumers said that they're open to new state privacy laws. For those of you that follow our legislature, it's very unlikely for something to be proposed or passed unless consumers fight for it and care about it. And as more consumers are interested in having privacy rights, and interested in requirements for businesses to respect their privacy, we'll see more and more of these bills being passed and proposed. A study by Axios found that 93% of Americans would switch to a company that prioritizes data privacy. So you could actually gain a competitive edge over your competitors by caring about privacy, right? So if a consumer goes onto your website, doesn't see a privacy policy, and doesn't have to agree to one before they submit their information, they might actually be thinking twice about doing business with your company. So having a privacy policy is a great way to show to consumers and prospective customers that you care about privacy. And then a study by Cisco found that privacy concerns can slow down the sales cycle by an average of 7.8 weeks. So it's really important to take that into consideration as well, especially when it comes to smaller businesses. 8 weeks is, you can't wait 8 weeks to do business just because you don't have the proper privacy practices in place. And then lastly, I think all of us should put ourselves in the shoes of the consumer and understand that privacy is a fundamental human right and we shouldn't abuse it. Because in reality, we all notice when somebody abuses our privacy, right? If you get those text messages that you never signed up for, or the incessant spam calls or the spam emails, it's not something that it's not something that makes you feel good, right? You get pretty upset about that because it's just a waste of your time because you never signed up for those things and you never wanted those things in the first place. And your customers will feel the same way. So having privacy practices in place and caring about privacy, make sure that the people who are receiving your message actually want to receive it, and can lead to higher opt-in rates or higher open rates as well, and higher purchasing rates, because the people who want your messages are actually getting it and the people who don't get them. All right, and then we are on to part 3, why you should be the one to talk to your clients about privacy. So you might be thinking to yourself, all right, well, I'm a website designer, a website developer, or I'm an agency owner, I'm a freelancer. Why is this my problem? Why can't my clients know about this from other sources? And why is it up to me to tell my clients about this? So really, unless your contract says so, there's really no requirement for you to talk to your clients about this, right? They can talk to their lawyer about this, or they can talk to their business advisors about this. But really, I think that you should be the one to tell your clients about this, because in reality, you know your clients better than anyone else. But if they are retaining your services to get them online or to get their business to stay online, they really probably don't know much about website development. They might not even know that you are installing forms. They might not know that you're installing Google Analytics, and they might not know what those things mean. So talking to them about privacy can make you look proactive and professional, since you're aware of industry trends. It can help you stand above your competition. So your competition might not be aware of these trends and might not be interested in speaking to their clients about them. And just having that extra layer of service can help you improve client retention and loyalty as well. And then lastly, it can help document this and protect your agency. So really, what you don't need to know all of the acronyms or all of the privacy laws or what a privacy policy should contain. You don't need to become a certified information privacy professional to talk about this to your clients. Really, what you need to say is, hey, I am putting forms on your website, or I'm installing Google Analytics on your website, and those services collect personally identifiable information. And I think you should look into having a privacy policy because you might be required by law to have one. That's it. That's really all it takes, is just telling your client that, and then they can do their own research as well at the end and figure out what they want to do with their business. But it can definitely help you protect your agency if you are telling them that. So really, your clients may look to you for advice on how to protect themselves while going online. And as more privacy laws pass, as more fines are issued, as more lawsuits take place over privacy rights or privacy policies, making sure that you document the fact that you told them that you need to have a privacy policy can really go a long way towards protecting you and your agency in case your client does get fined or sued in the future. So really, you want to make sure you protect yourself and your agency, and by doing so, you can actually help your clients as well. So you may be wondering, when do I tell my clients about this? So really, privacy laws start applying as soon as PII is being collected, right? So ideally, you want to make sure that you are talking to your client about this when you're initially quoting the project. So when you're initially quoting the project, you might be quoting different pages. One of the pages that you can quote building out is a privacy policy and a terms of service page. Or even with the forms that you're designing, having a little consent checkbox, making sure that people agree to the privacy policy before they can submit PII. That's a great time to talk about this stuff when you're actually quoting things out. Also before the launch of the website. So once the launch happens, obviously PII starts to get collected. So you would want to take care of this before launch, ideally. If you haven't talked to your clients about this and their website's already launched, don't panic. This is a relatively new thing. So it's not your fault that you didn't know about this. It's definitely happened just in the last couple of years, and it's been really ramping up in the last 2 or 3 years. So you can also talk to your clients if they're on a maintenance plan with you, or really any time is a good time to talk about privacy because it's something that's important. And then lastly, I did want to talk about where you can get privacy policies. So there's 2 sources where you can get them. So source number 1 is an attorney. You definitely want to get an attorney that actually focuses their work on privacy. You don't want to contact your state's attorney. Your business attorney might be able to help you, but it's really best to speak to a privacy attorney about this. So privacy attorneys can write a privacy policy for you or for your clients. It's a really good option for really big clients or clients that need special compliance, such as HIPAA or financial services compliance. Attorneys can get expensive. What I would do when choosing an attorney is I would ask them what their strategy is for keeping your privacy policy up to date. So how do they keep track of privacy bills? What happens if a privacy bill passes? And then also what the cost is of creating the initial policy, but also what the cost is of keeping that policy up to date. Because each time a privacy law is passed or a privacy law is amended, you're going to have new disclosures in your privacy policy. So that's going to cost extra. If you talk to an attorney and they just give you a blank stare, if you ask them how to keep things up to date, they're probably not the right choice for you. So definitely make sure you work with somebody who has a strategy for keeping things up to date. And then lastly, generators. Generator is a software as a service solution that basically asks your clients a series of questions and uses their answers to customize a privacy policy for them. They're usually faster and a more cost-effective solution than an attorney and can work for the majority of your clients. Before you work with a generator, also check on them, make sure that they are run by somebody who's reputable in the industry, that they have an attorney on staff, and that they also talk about these new bills. So those are the 2 options for getting privacy policies. So I know we're going to go into questions soon, but I did want to go through a few frequently asked questions that I get asked all the time during these presentations, just because I know that they usually come up and somebody's going to have this question anyway. So the first question that I usually get is, who's going to sue me for not having a privacy policy? So privacy laws are enforced in a different series of ways depending on the country in which the privacy law was passed. So in the United States, privacy laws are currently enforced by the state's attorney generals, who make sure that companies are following privacy laws. And then in other countries such as the European Union, you have data protection authorities, which are also in charge of enforcing privacy laws. And what's really interesting is that typically we used to have states attorneys general take care of this, but in California, we're actually getting a separate agency whose only job will be to enforce privacy laws. So that's something to keep an eye out for as well, because usually when that happens, there's more and more fees that are being issued. And then when or if certain privacy bills pass, consumers would be allowed to sue businesses directly. So right now, it's the government's job to enforce these laws, but in the future, consumers could sue businesses directly as well. Is my business too small to need a privacy policy? No, not really. So I would encourage everyone to Google search GDPR enforcement tracker, and there you'll see all of the fines that have been issued under the GDPR, which is the privacy law of the EU. As you can see there are a lot of really large fines, so multi-million-dollar fines that are issued, but you'll also be surprised that there are small businesses that are issued fines as well. So companies that have just one person or that infringe on the privacy rights of just one person have been fined thousands and thousands and thousands of euros as well. So no business is too small to need one in terms of the privacy law compliance portion. And then also in terms of the consumers caring about privacy portion, they still want to see that information being presented to them, regardless of the size that your business is. They're still concerned about you sharing PII with others and what you do with it. And then lastly, can I just copy and paste a template? There are a lot of templates going around right now, especially online. There's free templates, there's paid templates, there's everything across the board there. And really, when you copy and paste a template, you're just getting a privacy policy. You're not complying with the privacy laws that apply to you. So each privacy law that applies to you has specific disclosures that they require your privacy policy to make. So if you get a template that's not based on that, it's almost impossible for it to comply with all the laws that apply to you, because you don't know what laws apply to you and what disclosures it needs to have. And then also a template doesn't stay up to date. So when new privacy laws pass or existing privacy laws amended, it's up to you to keep track of all of that and make those changes. And I see a lot of people that download a GDPR template. And that's really an issue as well, because GDPR is just one privacy law. And even though it's one of the most stringent privacy laws, it doesn't include the disclosures that other privacy laws require you to include. So for example, CalOPA requires you to note how your website responds to do not track signals. GDPR doesn't. So if you get a GDPR privacy policy template, it's not going to be compliant with the other privacy laws that apply to you as well. So definitely try to stay away from those. And lastly, here's my email address. So if you think of any questions after this program, you're welcome to send me an email, and I'd be happy to answer any questions. So Josh, I'll take it over to you to moderate the Q&A.
Hey there, can you guys hear me?
Mm-hmm.
Cool, thanks Donata. That was a lot of great information. So I'll just jump over on the QA board and we can start there. So Oliver, I don't know if this was a question, but I usually provide a tweaked open source privacy policy template for my clients, but I make sure they are aware it's ultimately their responsibility to make sure it properly serves their needs. So I wasn't sure if, Oliver, did you have a question there, or Donata, any thoughts?
Sure. So Oliver, unless you're comfortable paying for the fines that your clients could face when that privacy policy becomes non-compliant, I wouldn't recommend it, because in reality, if you're not providing legal services, you shouldn't be providing privacy policies for your clients, because that can be considered a legal document, and that's a document that can get your clients fined or sued. So you definitely want to make sure that you're not taking that responsibility upon yourself to create privacy policies or privacy policy templates and provide them to your clients, especially when it comes to open source templates as well. I have never seen a template of any kind that first determines what privacy laws apply to that particular client. So it's unknown what privacy laws that template would comply with, if any. So really, you're just taking a lot of unnecessary risk upon yourself and your own agency when it comes to providing these types of documents for your clients.
Okay, cool. So the next one, Robson, should privacy policies, cookie consent forms also mention tracking from third-party services like YouTube or Instagram embeds?
Yeah, so it really should note any kind of service that you're using that has that tracking. And a lot of those services in their terms of service will require your privacy policy to contain specific language for that particular service. So you definitely want to make sure that you note that. So like a great example is Google Analytics. That requires you to include a link how to opt out of Google Analytics within your privacy policy if that's something that you're using. Same thing with cookie consent. Your cookie consent form should make sure that they list all of the services that you use and allow consumers to make a choice whether or not they want to consent to that tracking as well. And there are two things that I did want to mention here. So first, in privacy policies, there's two schools of thought. So one school is listing all of the third-party services by name with whom you share PII. So for example, saying MailChimp or Constant Contact. And another school of thought is saying the categories of third parties. So for example, email marketing vendors. And both of those are completely correct under privacy laws. But there is one big consideration to make there is switching providers. So a lot of businesses will switch providers. So let's say, and I have nothing against MailChimp, I'm just using them as an example. Let's say you're sick of MailChimp and want to move to Constant Contact. You don't want to have to update your privacy policy every single time you do that, right? Because that's just a hassle. So really you could just list the third-party categories and then, switch vendors however many times you want to without having to update your privacy policy. And then the second thing is cookie consent forms. There's so many bad ones out there, and it really gets to me on the inside that there are so many bad ones out there. Basically, what you want to provide is you want to provide the consumer with real consent. So with a real ability to make a choice. So for example, you have to make sure that only essential cookies are enabled by default and all non-essential cookies are disabled by default. And analytics and ads and all of that stuff is nice, but they're not essential. So when a customer goes onto the website, they have to be presented with an actual choice. So an accept and a deny button. And if they press accept, you can enable those non-essential cookies. If they press deny, they should not be enabled. And there really has to be a choice. There has to be an accept or deny. So all of the cookie consent forms that say just accept, or they say more information, or they say by using our website, we're assuming that you're okay with tracking, all of those are non-compliant. So definitely make sure that you're using a compliant cookie consent form as well.
Cool. Kurt asks, any special considerations for nonprofits? Yes.
So there are certain privacy laws that don't apply to nonprofits. So most privacy laws will apply to for-profit businesses only. Two really important exceptions to that are the General Data Protection Regulation and the United Kingdom Data Protection Act 2018. So even if you're a nonprofit, you still have to make sure to comply with those. But most privacy laws do exempt nonprofits since they apply to commercial websites, and nonprofits do not undertake commercial considerations.
Cool. I have a question, it's kind of like web accessibility and all the guidelines that are required. It's so comprehensive and confusing. Mm-hmm. What does Termigen do to take the headache out of, building all these terms for businesses like us, agencies, freelance developers?
Yeah, so what we do is we create privacy policies, terms of service, and disclaimers for businesses. So it's essentially a series of questions. So the first set of questions will help us determine what privacy laws apply to you, and therefore what disclosures your privacy policy needs to contain. And then the remainder of the questions are based on that. And then your answers are used to create a customized set of policies for you. So we create the policy text, and then we also create an embed code. So the embed code is what goes onto your website's privacy policy page and displays the text. And then it's also what allows us to make updates when laws change or new privacy laws are passed. So we also monitor those and make updates to your policies as well. And then we have an agency partners program where you can get a free license for your agency, and then also a way to resell the licenses to your clients and make some recurring revenue. So if you're interested, you can hop on to termigen.com. And you'll see the agency partners page at the top. You just click on that and then apply at the bottom. And then we'll issue the free license and then also provide resources for you to communicate this to your clients. So a great example is a policy waiver. So it's a waiver that you can have your client sign that basically says that we're not responsible for your policies. It's up to you to make sure that your website is compliant. So it's definitely something that really helps a lot of our partners.
Okay. And just to follow up on that, I know that we don't do it enough, but like the GDPR, like consent pop-ups that say like, whatever the policies are, do you guys provide a widget for that too? Or is that something that developers need to build out?
So we're actually partnering with a company to build out the widget right now. But before it's available, I did want to note we're partnering with User-Centrics, which recently purchased CookieBot. So those are one company right now. So we're partnering with them. So until we actually get it into our dashboard because it's under development, I would definitely recommend working with User-Centrics or the CookieBot portion of User-Centrics, because really after doing a lot of research, they're the only ones that I've found so far that are truly compliant.
Cool. I don't see any other questions unless someone has like one last one to squeeze in here. But I'm not seeing anything come through.
I see a comment from Oliver. Says, tricky one. I'm UK based, so not sure what's required here specifically or who's liable for a site's actual content. So in the UK and across the world, it really depends on what your contract with your client says. So if your contract with your client says that you're responsible for privacy law compliance because you took a contract template from online without reading it and used it with your clients, then it's on you to make sure that that site is compliant. Otherwise, the client would be liable for the site's actual content. However, if you are providing compliance documents to your client and representing that those documents are compliant or representing that you reviewed those documents for compliance, you can actually become liable for those documents as well, such as a privacy policy template that you provide. And in the UK, there's quite a lot of enforcement of your privacy law. So in the UK, you have the UK Data Protection Act 2018. And you can look up your Data Protection Authority's website and you'll see in their newsfeed the fines and the lawsuits and all of that have been issued. So, it's really not, at least in my opinion, it's really not worth it for your agency to potentially take on millions and millions of euros of liability by just providing a privacy policy template to your client. So I know that everyone is, you're trying to be helpful, right? And I think a lot of agencies, they really want to be helpful and they want to help their clients. But by providing a privacy policy template, you're not actually helping them, you're harming them. So the best way to do this is to say, hey, you have forms, you're collecting PII, you need to look into having a privacy policy, right? And we can't provide that privacy policy for you because we're not a law firm or because we don't have the expertise in this area, but you really should look at these options. So whether they're looking at a generator like Termigen or they're looking at working with an attorney in their area, doing that will help take away that liability from your agency because you're not going to, regardless of what kind of website you build, you're not going to make enough money off of that website to be able to cover the potential fines that client is going to be subject to for a privacy policy that's not compliant. So the best way to help your clients is just inform them that they need this and then send them to a couple different resources that they can check out, and they can, those resources can take over that responsibility then instead of you. Josh, I think you're on mute if you're trying to talk.
Yeah, classic move. Thank you so much. Got some great information there. I didn't see anything else pop up. So Donata and everyone else, feel free if you guys want to jump into a session and ask more questions after this, or just get in touch directly with Donata to ask about what else they can do to help you guys.
Awesome. Yeah, thank you so much for having me.
Yeah, we appreciate it.
Of course. Bye.
All right, take care.